Thank you. Welcome back. So we were dealing with Rule 45, which is golden rules relating to pleadings, and we dealt with up to sub-rule 7. So let's proceed to sub-rule 8. Perhaps before I proceed, up to now, dealing with pleadings in general, are there any questions that you would like me to answer at this stage? Delivery of pleadings was always a requirement, even before the new rules. But it's a distinction for the simple reason that you serve something on a party and you file it at court, and service and filing together makes up delivery. So you can't talk about I delivered it on my opponent. You served it on your opponent, and you filed it at court, and therefore it's now been delivered. So it really is two different concepts, and together they are referred to as having delivered. Okay, so you'll have particulars of claim, your summons it's a combined summons, so it's summons with particulars of claim. What must follow then, I'm only speaking about notice, a pleading, so I'm not talking about notices in between, that we'll deal with later. So what will follow is a plea and possibly a counterclaim. Then what will follow is possibly a replication to the plea, and if there is a counterclaim, a plea to the counterclaim. So I wonder if I can, I suppose I can write it down here. So you'll have your plaintiff, and you'll have your defendant. Plaintiff will file a combined summons, which will then include the particulars of claim. Then a defendant, if he or she wants to defend, this will be step 1. If he or she wants to defend this action, step 2 will be to file a plea. The plea deals with this. And together with this will be the counterclaim. If you want to bring, this is optional. So if you want to, as a defendant, file a counterclaim, you can do that, and you must do that then together with your plea. You can't file this at a later stage, you can then only do so with leave from the court. So this will be step 2, definitely this, and possibly combined with a counterclaim. Then step 3 will be a plea to the counterclaim. That's of course only if there was actually a counterclaim. And a replication. The plea is to the counterclaim, and the replication, this is also optional, to the plea. You follow. Then step 4 will then be either a replication to plea to counterclaim, again optional, plus a rejoinder to the replication. So this one would go there, and this one goes there. Then step 5 would be a rejoinder and a surrejoinder. Rejoinder would be to this replication, and surrejoinder would be to this rejoinder. And then 6 would be surrejoinder to this rejoinder. Does that make sense? It looks like those exercises that my daughters do in school. Which one goes with which one, and they draw these little lines. But that's essentially how it works. So you'll have, if in a fully fledged, all pleadings exchange type of action, you'll have 6 steps. You'll have these 6. You'll have the combined summons on its own. To the combined summons, and now considering that all pleadings are filed, counterclaims, etc., you'll have a plea and a counterclaim. Then you'll have the plea to the counterclaim and the replication, which is to the plea filed here. And then 4, you'll have a replication to the plea, which is that one, and possibly a rejoinder to the replication. Then you'll have a rejoinder to this replication and a surrejoinder to this rejoinder, and then you'll have 6, a surrejoinder to this rejoinder. Does that make sense?
It makes sense whether we will remember those last ones.
I mean, rejoinder and surrejoinder, as I said, is not something you deal with very often. So I suppose what you can do to make it easier is to say, this one, the green one is the original. Oh, this one isn't working. Okay. The green is is the main one, the main action. Plea, replication, rejoinder, and surrejoinder. All the green is the main action. And then you can take the blue, you can say counterclaim, plea to the counterclaim, replication to the plea to the counterclaim, rejoinder to the replication, and surrejoinder to the rejoinder. And these, the blue is the counterclaim. So it's exactly the same procedure for a main claim and the counterclaim. They just follow in sequence. So because the counterclaim is only instituted here, you'll see it ends later. So this is step 6. So 1, 2, 3, 4, 5, 6, and 6 will be your surrejoinder on the counterclaim. But you'll see it's the summons, then the plea, then the replication, the rejoinder, and the surrejoinder. You have the counterclaim, the plea, the replication, the rejoinder, and the surrejoinder. It was removed from the rules. It was removed in South Africa quite some time ago, and in the new High Court rules you can't seek particulars. The approach is simply that litigants should plead in a manner that is sufficiently setting out all the detail required to plead thereto. So you wouldn't be, if you need to request further particulars, then the pleading wasn't drafted properly. You can still seek further particulars for purposes of trial, so what we call trial particulars, and I'll deal with that then when I deal with the pre-trial procedures. Now bear in mind that these steps, 1, 2, 3, 4, 5, that's just pleadings in general. Those are the exchange of pleadings in an action. That's not to say that after this will happen, because here might come in an exception, or here might come in a request for trial, a request for security for costs, or here might come in a summary judgment application. So it's not to say that it will most certainly follow this 1, 2, 3, 4, 5, 6. It's not to say that it'll happen. It's just that in the normal course of events, all matters remaining equal, this is the sequence that you can expect. So that's the exchange of pleadings by a plaintiff and a defendant in an action. And I'll explain, we're dealing with a combined summons at the moment, and I'll explain to you the plea, what's required for the plea, how and when it is filed and by whom, and then I'll explain to you the replication, what it's for, the rejoinder, what it's for, and the surrejoinder, what it's for. Joinder and rejoinder and surrejoinder, you probably won't be dealing with too much. But I mean, it's there. You need to know that it's there. All right, let's then proceed. If there aren't any other questions on this, okay. Then we were dealing with sub-rule 7 of rule 45, so let's proceed to sub-rule 8. It is not necessary in a pleading to state the circumstances from which an alleged tacit term can be inferred. So for instance, you'll see if you look at AMLA's precedents of pleadings, and this used to be the position, let me just get to tacit terms. A party intending to rely on a tacit term in a contract may, in addition, have to disprove the allegation that an express agreement was reached regarding the aspect covered. A party seeking to place a construction on a document that differs from the document prima facie its meaning has to plead the circumstances, and then it continues to say that you would have to prove, or you would have to plead the circumstances relating to why you say it's a tacit term. That's been removed. It's dealt with in our rules to say it is not necessary in a pleading to state the circumstances from which an alleged tacit term can be inferred. So you make the allegation that it's a tacit term and you need not plead the circumstances. So for instance, I can say it was a tacit term of the agreement that that Mr. X would sell me his car at market value. And then it's a tacit term because when Mr. X and I discussed the matter, I said, well, I think market value is probably a reasonable approach, and market value can be established. We just go to AA and we get the market value of the car. And so great, we shake on it, doesn't say anything, goes home. I later send him an email and he just says, good, there's no agreement particularly. So in his behavior, he has shown that he agrees with me, and therefore we have a tacit agreement. You see what I'm saying? So you don't have to plead those surrounding circumstances. Then sub 9, a plaintiff suing for damages must set them out in such a manner as will enable the defendant reasonably to assess the quantum thereof. So you can't say, as a result, I suffer damages in the amount of 10 million Namibian dollars, and now I seek. You must say what those damages are for. So you'd say, for instance, I suffered, say for instance, medical negligence. You'll say suffered pain and suffering, loss of income, what other permutations of damages there are, you'll set them out. So motor vehicle accident damages, you'll say my car was worth this. Pre-collision, post-collision, it's worth this. Therefore the difference is this, and these are the damages I suffered, or it's now not economically viable to have the car fixed, so therefore you have to replace market value minus scrap salvage value. This is how I get to the amount of damages. Or contractual damages, as a result of your breach, I suffered delay in finishing the main contract at penalties of this whatever a day, and I suffered damages because I had to keep staff on the site longer, etc., etc. You need to set out how you arrive at the amount of damages that you claim, because your opponent must be able to say, no, but that couldn't have been a damage that you suffered, it's too remote, or this is incorrectly calculated, etc., etc. So the opponent is entitled to know that. A plaintiff suing for damages for personal injury must specify the nature and extent of the injuries and the nature, effects, and duration of the disability alleged to give rise to such damages. So, for instance, you were in a car accident, or maybe that's an MVA issue, let's leave that for a moment. You, medical negligence, as a result of the negligent actions of the medical practitioner, you were incapacitated in that you were hospitalized for 4 weeks. You couldn't work for 4 weeks, and as a result you suffered obviously loss of income and pain and suffering because you were on painkillers, you couldn't walk, didn't have full faculties and functions of your body, etc., etc. You'd set that out concisely in order to assess, for your opponent to assess how your damages are made up. Then sub 11, in a claim for damages for personal injury, that's the one we're busy with, and what amount, if any, is claimed for medical costs and hospital or other similar expenses, pain and suffering and disability in respect of the earning of income, stating the earnings lost to date and the estimated future loss, and the enjoyment of amenities of life, and giving particulars. So you lost your hand, and as a result, you can no longer play golf, which is your hobby, and you can no longer drive your children to school, or what it is that you lost as a result of this injury. And as a result of that, an actuary or someone would have calculated the damages that are relevant to such a loss of limb or loss of amenities of life or whatever. So generally, those are the principles applicable to particulars of claim, summons, particulars of claim. So you'll have, you'll have citation of the parties in the particulars of claim, you'll have your cause of action, you'll have your damages or what it is that you're claiming, and you'll have your prayers where you say, as a result of what's stated herein, I now claim the following. And then you set out your prayers. So the example is in your file. You'll see there that's always the sequence that a particulars of claim follows. Service of a summons. Summonses are served by the Deputy Sheriff. You can read about summonses in Rule 8. Please note that for matrimonial proceedings, which is divorce proceedings, the personal service is required. There are exceptions to the rule where, for instance, the defendant cannot be located or personal service cannot be effective. You can seek an order for substituted service, which we'll speak of in a moment. I did mention to you the reference to domicilium citandi et executandi. That would be a chosen place where you would accept service. It's pre-arranged and pre-agreed between the parties, and then you are entitled to serve on the domicilium citandi. You have to serve on the residence or the principal place of business, the registered office, or the place of employment. So these are the places where you would serve a summons on a defendant. Your return of service is what is prima facie proof of service. You'll see Rule 9, 10, and 11 deals with service and returns of service. I'm not going to go through those rules in detail at the moment, but please be aware that those are the rules that deal with what is required for service of summons. And of course, remember that if there wasn't proper service, then the question remains, has the action actually come about? Now, there's authorities to suggest that service of summons is really just to bring the summons or the action to the attention of another party. And if you file a notice to defend, which isn't regarded as being taking a new step in the proceedings, you as a defendant may raise Rule 61, which is the rule dealing with irregular proceedings, which I'll deal with tomorrow in a session. You may be able to rely on that, but the question remains then, I suppose, what prejudice did you suffer, which is a requirement for Rule 61, because service was really to set everything in motion and notify you that I'm taking you to court, and now you're here, so you've been notified, so service may have been not strictly in compliance with the rules, but what prejudice is there? So these are difficult questions. If it's a default judgment and there's no proof in the form of a return of service that shows that service was done in compliance with Rule 9, 10, and 11, or any order of court granted, then I suppose it's quite clear that default judgment cannot be granted. A return of non-service would be where a deputy sheriff is unable to serve the summons on the defendant on one of the given addresses, which means that there was no service. So return of non-service means no service. Edictal citation is Rule 12. I think it's important to understand and know what Rule 12 requires. It's again an application made by way of motion, so it's an interlocutory or a preliminary application that you would bring. It's to serve, process, or document outside Namibia wherein proceedings are instituted. So the general point of departure, as set out in Rule 12, Sub-Rule 1, a person may not serve any process or document outside Namibia. That's the process of this court, whereby proceedings are instituted in the court, whether the address of the person to be served is known or not, except by leave of the court granted in terms of this rule and subject to Rule 11(1)(b). So you make application in terms of Rule 12, set out what the claim is that you have, the grounds on which you say this court has jurisdiction for you to then issue summons here and serve it there, and the manner of service which the court is asked to authorize. So for instance, Facebook account service has happened in the past. I've recently in Mauritius, we served by way of registered usher, which is much like a deputy sheriff here. So you find out what the process is in that jurisdiction where you want to serve. Service by a lawyer, service. So you try and keep as far as possible to the requirements of Rule 9, 10, and 11. If you deviate from what is set out in those rules of what service should be, then you should explain why in your application and seek an order that service be done in a particular manner. And then, of course, if service is proposed other than personal service, you must set out the last known whereabouts of the person. So it's sort of a combined substituted service / edictal citation possibility in terms of Rule 12. And then the court can make an order as it deems fit, and if it grants you the opportunity, then I think it's Form 2 if I recall correctly. The service may be on Form 2, which is then of an edictal citation, which is a process of this court served outside this jurisdiction. Edictal citation you would use often and see often in matrimonial causes where the wife or the husband is here as plaintiff and wants to issue summons against a defendant, husband or wife who is outside Namibia. You would often find edictal citation applications for that. Substituted service. Any questions on edictal citation? Substituted service is Rule 13. So, of course, where it's impossible to do personal service, for instance, in matrimonial causes or outside Namibia, you may need to, as I said, Facebook accounts, newspapers, serve on a family member who you know is related, speaks to this person often or has spoken to him in the past year, is able to find him, email account, or all of the above. If you know this person has a Facebook account, you know this person has email, you know that he's in an area where there's newspapers, although you can't make telephone contact with him or her, you don't know where they physically are, then these are the things that you'd use to try and make sure that he or she gets notice of the proceedings. It's very important. Service of summons is a very important and often overlooked aspect of the procedure, simply because if a party to proceedings, a defendant, isn't notified of an action against him or her and it proceeds to default judgment and judgment is granted, then really that person is being deprived of his or her constitutional right to defend the matter and to a fair trial. So it's very important to establish service, particularly where there's a request for default judgment. And also where applications for substituted service are made, that parties are not trying to avoid service and notice to the other party by seeking ridiculous manners of substituted service. So as much as possible, as wide as possible, to ensure that this person will reasonably gain knowledge of the action that's to be instituted against him or her. So Rule 12 and 13, 9, 10, 11, 12 and 13 are important rules. So we've dealt with Rule 6, Rule 8, Rule 7, and now 9, 10, 11, 12 and 13. Then I want to deal briefly with joinder, which is Rule 40. You must understand that joinder is different from consolidation. Consolidation we'll deal with in a moment, but joinder is done under Rule 40. You can look at the authority, the Amalgamated Engineering Union versus Minister of Labour, 1949, Volume 3, South African Law Reports, page 637 in the Appellate Division. And it deals with what joinder is all about and when it is used. And it's important to be mindful of the principles relating to joinder already at this stage of proceedings, at particulars or claim stage of proceedings. So if I can just turn to to Rule 40 for the moment. It really deals with joinder of parties and joinder of causes of action. So what you may have is a number of permutations dealing with joinder. So you can have, when you're dealing with joinder, you can have joinder of parties, so plaintiffs. You can have joinder of defendants. And you can have joinder of causes of action, or a combination. Joinder of plaintiffs would be, for instance, if I'm to think of an example that I did recently, would be 3 plaintiffs. It's the same project, building project. 3 plaintiffs, all subcontractors, all want to sue the main contractor for unpaid amounts in terms of the contract. So 3 plaintiffs, 1 defendant. Same contract, well, same works, and it relates to the same cause of action, although each of them have a separate cause of action relating to their contract. So you'll have the first plaintiff's claim against the defendant. You'll have the second plaintiff's claim against the defendant, and you'll have the third plaintiff's claim against the defendant. What you wouldn't want is if this plaintiff has a claim against defendant 1 for MVA, and he has a claim against defendant 2 for goods sold, and he has a claim against defendant 3 for breach, let's say. You can't combine these 3 in one particulars of claim because they have nothing. It needs not be dragged into what was set out between these, and the same goes for each of the others. So you can't do that. But if it's one defendant and the 3 plaintiffs are more than happy to all join forces to sue, you can do that in one particulars of claim and get it over with, one trial. But you can't do this. So you can have more than one defendant and join them if both defendants relate to the same cause. So it's the same cause of action. So you may have suffered, let's say, medical negligence, and defendant 1 is the hospital, and you feel that the hospital was negligent because they didn't prescribe the correct medication, and this is the doctor. So you feel the doctor didn't come and see you, and therefore he's also negligent. Then you're entitled to sue both. It's for the same operation, same procedure. You can join them together in one cause of action. So you see how they are supposed to connect. You can't just say, I have 4 claims against 4 different persons, I'm going to do it all in one, save myself the time of issuing 4 summonses. Doesn't work that way. So be mindful of the fact. Causes of action, say for instance, this is the plaintiff and the defendant, same plaintiff, same defendant, but they have one claim for MVA, one claim for monies lent and advanced, and one claim for breach of contract. You can issue one summons against this defendant for each of these causes, setting them out as separate claims. Okay. Doesn't mean that you're not entitled to issue 3 summonses. You can do that also, but why would you if you can conveniently combine them in one? So that's the issue of joinder. Joinder of necessity is where, for instance, I want to sue, let's think of a practical example that's, so I want to sue, the relief that I'm claiming against the party involves the liquidation of a closed corporation. So let's say I'm a member in a closed corporation and Mr. X is the other member. We are 50% members. And I want to seek an order from the court that the closed corporation be wound up because we're at a deadlock. We can't do business anymore. We're at a deadlock. I want to liquidate it, wind up the CC. Of course, the closed my fight's not with the closed corporation, which is an entity on its own, but the relief I'm claiming against this co-partner of mine, co-member, will obviously affect the closed corporation as an entity, and therefore, when I draft my particulars of claim, if you're going, you probably won't be proceeding with the particulars of claim in that example, but I'm just trying to explain the joinder of necessity. You would join that closed corporation as a party. Although your fight's not with the closed corporation, your fight's with a member, your relief will also impact on the closed corporation, and therefore it's joinder of necessity, joining a party to the proceedings as necessity. The same would go, for instance, where you're suing certain government institutions, where the statute says that a certain line minister is responsible for what's happening under this act, then that minister would be a necessary party because he or she would have an interest in the subject matter of the suit. So that would be a joinder of necessity. Joinder of convenience would be many of the examples I've explained to you there on the board, where it's convenient for you, you're suing the same guy and you're suing for 3 causes, you list them separately, each cause in one summons, or where 3 plaintiffs together sue 1 defendant, or you have different defendants that you want to sue for the same event. That's joinder of convenience. What is a necessary party? That goes back to the question I posed in one of my previous slides, which says, if the order that you are going to grant or could potentially grant will affect a party's rights who is not before court, then that party should be joined because that party is a necessary party. So you're a necessary party when you have a legal interest in the matter and particularly in the outcome of the matter, and an order or potential order that can be made in this matter will affect that party's rights. In whatever remote manner, that party is a necessary party. So you'll find a lot of authority on necessary parties. Then you have what is called intervention, Rule 41, which is also important. You can read the rule in your own time. But intervention is really where a party is notified or receives notice of proceedings. For instance, the plaintiff in a medical negligence claim is suing the hospital for negligence and for damages suffered, etc., etc. The doctor who performed the operation may feel that he or she has an interest in the matter for whatever reason and permutation of the facts. He or she has an interest. He or she is entitled, in terms of Rule 41 of the High Court rules, to intervene. So they make an application to court seeking an order in terms whereof they are allowed to intervene in the matter as a plaintiff or a defendant. It may very well be that the doctor intervenes also against the hospital or in order to defend the claim against the plaintiff because the doctor feels the order that will be given here will impact on him and the hospital is not properly defending, so he or she wants to defend. So as long as you can prove a basis, party can prove a basis upon which he or she should reasonably be joined to the proceedings, through an intervention in terms of Rule 41, which really sets out the applicable principles, he or she would be able to intervene. I'm trying to use simple as possible ways in order to illustrate to you. So if I think of a practical example in practice that I've recently come across, or in the near in the past, it would be, for instance, where a party sues a financial institution for relief relating to principles applicable to mortgage bonds and foreclosure of mortgage bonds, which means that, let's say, the plaintiff sues, let's say, F&B, and the issues to be decided here relates to mortgage bonds. This is something in which Bank Windhoek, Standard Bank, Nedbank, possibly Bank of Namibia, all would have an interest in. But they're not necessary parties, because what the plaintiff, probably not necessary parties, because the plaintiff is only talking about his mortgage bond. But what will happen here is what will be determined here will set a principle which will be applicable to these. So therefore, these would be entitled to intervene, to say, no, wait a minute, what you are deciding here relates to a principle which will then apply to us, which will have an effect on us, and as a result, I want to join the fight, and I want to also fight this, I want to also be heard. I don't care about the relationship between F&B and the plaintiff, but I care about my position given the principle that you will be establishing in this matter. You've ordered to join a party, or a party intervenes, he or she will be given the right, he or she will be served with all the pleadings to date, and he or she will be given the right through an order, and the order must of course set out what will now happen. This joint party, who's now, say, a defendant, will have the right to plead, will then have the right to bring a counterclaim, etc., and will then follow the steps until all the pleadings have closed. So he or she or it will be granted an opportunity to take all the steps as if he or she had been a party from the beginning. A diligent practitioner and diligent litigant should be seeking such an order, should be seeking an order from the court setting out what the procedure is to follow. But whether or not that procedure is or that party seeks such an order, the court is obliged to make an order to say how the parties should further then conduct themselves now that a new party has been joined. That's why it remains, I suppose, the responsibility of the judge hearing the application and granting the order for joinder to say, well, then serve now on that party all the pleadings to date. If you haven't done so, give them so many days to plead or to whatever, file a counterclaim or what it is that you want them to do as a defendant. So to answer your question, a prudent practitioner may seek such an order. The court should nevertheless grant it or set out how procedurally matters should proceed. Okay. Special pleas, joinder and misjoinder, non-joinder and misjoinder. These are special pleas that can be raised where parties have been incorrectly joined or where they have not been joined and they should have been joined. So non-joinder, if I acted for F&B in this scenario, then I would probably have raised an issue of non-joinder, because I would say, well, you're asking the court to decide a principle which will have external effect, and these external parties are these, so you should have cited them at least, and in fact you should probably publish service in order to see whether there are any other third parties that may have an interest in this external principle that you're trying to determine. So I would have raised non-joinder here already if I had acted for F&B in this matter, and say, where are these parties? They have an interest. Misjoinder would be if I cite someone as a party against whom I have no claim whatsoever. So I have a claim against, or someone has a claim against my husband, say for instance he disobeyed the traffic light and he bumped into someone's car and with his own car, and he is now sued, and I'm married to him out of community of property, didn't drive my car, didn't work for me, the only thing is that we married, and I'm now cited also as a party. It would be a misjoinder of me because I have no interest in the matter. So that would be misjoinder. So that's the difference between non-joinder and misjoinder. It's raised by parties at plea stage. And of course, courts should be mindful of the issue of misjoinder and particularly non-joinder, where in instances such as this, where external parties who you don't really even know who they are may be affected. For instance, parties want to apply for the registration of a post-nuptial agreement. They may have signed or agreed prior to their marriage to enter in, to be married out of community of property, but they never signed the correct documents, or the ANC wasn't registered within 3 months at the deeds office, and then they may want to seek relief from the court to now register it. They may in the meantime actually have incurred debts. So they may have creditors with vested rights who extended credit to them or gave them loans based on the fact that they were married for all intents and purposes in community of property. And those creditors will have to be cited in such, they need to be joined. And these are questions that you need, the order that I'm making, changing their marital regime, would it be that I'm affecting someone else's rights without me knowing this, without such party being a necessary party? And then comes up questions such as creditors would be the most pertinent issue that jumps to mind in such an instance. I'm just trying to again explain by way of example how these things work. Joinder of different causes of action, that's Rule 40, and then please distinguish from consolidation. So consolidation is where you have two matters between two separate actions and they are consolidated into one action for whatever reason. There are guiding principles. You can't just simply consolidate many matters. There must be underlying principles, but we'll deal with consolidation a bit later. All right, that deals with joinder and the like. Defending an action. Notice of intention to defend, Rule 14. Remember that a notice of intention to defend does not amount to taking a further step in the proceedings, and it also is not considered a pleading. The requirements for a notice of intention to defend is set out in Rule 14, Sub-Rule 3. You can have a look at that. And then please be mindful of the fact that simultaneously with the delivery of a Rule 6, or with the delivery of a Notice of Intention to Defend, you also need to deliver a Rule 6 return, similar to the one that you deliver with your action if you institute it. I just want to mention one thing here that's also important. It's dies non. So you'll find that in the rules. I'll take you to the specific rule. And this is important for the timing of when a default judgment, or when a particulars of, when a notice of intention to defend needs to be filed. So you'll see Rule 14, Sub-Rule 1. The days from 16 December to 15 January, both inclusive, are not counted in the time allowed within which to deliver a notice of intention to defend. So you have 10 days after service, unless you are the government, in which you have 20 days after service of the summons to file a notice of intention to defend. If that, so let's say it's now 16 December. So just to explain this principle, it should actually just sort itself out on e-justice, because those days should be excluded as days counted automatically by the system. But we all know that systems fail us sometimes, so there's nothing as wonderful as the human mind and knowledge. So for understanding this, let me just explain. So it's called dies non. Dies meaning time, and non, this doesn't run as time. 16 December to 15 January, both days inclusive. So let's say, for instance, summons is served on a party who's not the government on 8 December. Now remember, court days in the High Court, it's only weekdays, excluding weekends, public holidays. So 8 December, which is a Wednesday. Then you won't count 8 December, you'll count the next day as day 1. So it's 9 December, so Wednesday, Thursday, Friday, Saturday, Sunday, so it's 9, 10, 11, 12, and then Monday, 12, 13, 14, 15, 16. So it's served on the 8th of December. So this would be 1, 2, disregard those, 3, 4, 5. You can't count this one, it's excluded. So you only have 5 days in this year. And then you start again. 15 January is excluded. So you count, let's say it's a Wednesday, 16, 17, 18, 19, 20, 21, 22, 23, 24. So now you have 5. So 6 will be here. 6, 7, 8, disregard those 2, 9, 10. So 22 January will be the due date. Do you follow this? So you exclude these, including 16 December, including. So you stop counting at 15 December and you start counting on the first business day after 15 January. In this case, it was 16 because 16 was on a Wednesday. Does that make sense? So if its service of summons is on 8 December, 10 days would have passed by around about 20 December already. But you don't count it, so you continue to count in January. So you can only regard it as being not defended once 22 January has passed and there's no defense. Does that make sense? Okay, just be mindful of that. All right. Default judgment. So default judgment is granted in a number of instances, or can be granted in a number of instances. The most pertinent one at the moment, of course, is where the time for filing a notice of intent, for delivering a notice of intention to defend, has expired and no notice of intention to defend was delivered, because e-justice would then automatically render it a default judgment matter, and then it may be applied for. Now remember, in terms of the old rules, a registrar was able to give default judgment in certain instances. That has been abolished. The Constitution says that orders, a court must be a tribunal, a court. So therefore, default judgments are granted by the court, by judges, in all instances. It's applied for by a party who is on the receiving end of default. Default in delivering a notice of intention to defend, the most pertinent one. Default of complying with a case plan, default of complying with case management, etc., etc. Default. In other words, the party has not done something he or she procedurally should have done, and as a result, I want judgment in my favor. It is applied from whom is default judgment applied for? It's applied from the court. In the previous dispensation, it was a requirement to place someone in bar when they didn't deliver their plea or whatever procedural step they wanted to take after notice of intention to defend. That has similarly been abolished. So essentially you are now ipso facto barred if you don't do what procedurally you are required to do. And if you want to then later take that step, you'll have to apply for a condonation and upliftment of the bar. Failure to appear at the hearing, say for instance everything has been finalized and the matter is set down for trial and your opponent doesn't appear at trial, of course you are entitled to seek default judgment, provided that of course you are entitled to default judgment based on the allegations that you've made and based on the whatever evidence you are required to prove or to present to prove your case, for instance, for damages. So remember, default judgment may be applied for by either the plaintiff or the defendant. So for instance, in failure to appear at the hearing, the defendant can ask for default judgment in the form of dismissing the claim. And then notice of intention to defend is filed late. What now? These days, it's probably going to be a e-justice issue that you'll have to sort out. But as long as a notice of intention to defend is delivered before judgment is granted, default judgment shouldn't be granted. You follow. It's different from in the magistrate's court. So please bear that in mind. Even if it's late, as long as it's filed before default judgment is granted, then default judgment shouldn't really follow. All right. You file the notice and you'll probably have to file an application to say this is why it wasn't filed earlier. But generally the approach, as I experience it, is to be that once it's filed or delivered, notice of intention to defend, no default judgment will follow from that. Whether the court will then require you to file an affidavit explaining, that probably depends on the judge you're dealing with. To be procedurally, strictly speaking, correct, you'd have to file an application to say, I'm out of time in terms of the rules, this is why. And there may be a plausible explanation. So strictly speaking, yes, you would be required. But many judges take a pragmatic approach and say, well, it has been delivered now, can we not just, let's just proceed. That's just depending on the approach. Matters differ. 1 day late, 3 days late, 2 months late, it just differs. It depends on the circumstances. Okay, well, a defendant would be entitled to seek default judgment, for instance, where a party doesn't arrive at the hearing or show up at the hearing, where the plaintiff doesn't show up. The matter is set down for trial. The defendant would seek that the claim be dismissed with costs. Of course, that would be default judgment because the court never heard the merits. It's really a default judgment. The same would be, for instance, where a defendant has, a plaintiff has failed to deliver witness statements, for instance, in non-compliance with the order of court. Then a defendant would be entitled to seek an order from the court to, it's basically comes down to sanctions, which is part of the case management part of the course that I'll deal with tomorrow. But it then essentially what he's asking the court is to give default judgment by striking the particulars of claim and dismissing the action, or something similar to what is contained in the rules relating to sanctions, which I'll deal with tomorrow in case management. Okay, so the next slide, which hopefully will be here soon. What are the necessary allegations for a default judgment application? A default judgment application would be, it depends on where in the process you are. So it would be summons was served, was properly served, here's proof of service, and time has expired for delivering a notice of intention to defend, and no notice of intention to defend was delivered. Or, for instance, a court ordered that the parties do certain things and not do certain things. The parties did, my opponent didn't do that, and as a result, I'm entitled to default judgment. Where it's default judgment for damages, you would be required to deliver either a damages affidavit by an expert proving the damages suffered, alternatively to lead the evidence in oral fashion in motion court to hear the evidence on damages before default judgment can be granted where damages are sought. Okay, then just briefly, rescission of judgment. There are presently 3 instances in which you can seek rescission of judgment. One is Rule 16. The second one is Rule 103, and then the common law. So essentially, a rescission of judgment is an application. It's brought on motion, which means that I'm not going to deal with you on the construction of that application now because I'm not dealing with motions. But it's important to understand the principles relating to rescission of judgment, and in particular where we're dealing with default judgment, or that would be Rule 16. So Rule 16 deals with rescission of judgment granted in the absence of a party. So default judgment, any permutation of default judgment can then be rescinded by way of Rule 16. Rule 103 is also where it's also rescission of a judgment which was erroneously sought or erroneously granted, contained a patent error. I just want to take you to Rule 103 because it's important to understand the difference between Rule 16 and Rule 103. So you'll see Rule 16 says a defendant may, within 20 days, I think that time period is 6 weeks in the magistrate's court, but in the High Court it's 20 days, court days, after he or she has knowledge of the judgment referred to in Rule 15.3 and on notice to the plaintiff, apply to the court to set aside that judgment. And then the court may, on good cause shown, good cause meaning explaining the delay or the non-compliance, for instance, explaining why you didn't file a notice of intention to defend, and then good cause also showing that you have a bona fide defense on the merits. So you have something worthy of actually going to court with. You don't have to prove your case on a balance of probabilities. It's a prima facie case. It's a low threshold test, but generally that's what good cause entails. And then the court may, you must set security, and then the court may apply for a rescission of judgment on motion. If you look at Rule 103, you'll see, let me just page there. You'll see that you can apply to the court. The court may do so out of its own initiative or on application of any party affected, brought within a reasonable time, rescind or vary any order or judgment erroneously sought or erroneously granted in the absence of any party affected thereby. So again, default, but not default in the sense that I wanted to defend and you were right to grant the default judgment, but for the fact that I was not there. This is where the court, for instance, erroneously granted it because it thought that the party was applying for an instance, erroneously sought. I had once obtained a number of motion court instructions from a particular firm. It was some 10 years back when we still went to motion court with piles of matters, and one of the 3 or 4 of the matters related to summary judgment applications. And in one of them, there was no affidavit filed, but the parties had agreed to postpone the matter for 3 weeks for the other party to file the affidavit. I had mixed up that instruction with another file and thought that in that particular matter I had to move for summary judgment. And the court granted summary judgment because I didn't realize that I was dealing with a matter where the parties had agreed to postpone, and of course didn't tell this to the court. So as soon as I phoned the instructing practitioner informing him of the summary judgment that was granted, he said, no, but this one is the one that we wanted the postponement. So immediately we brought an application to say it was erroneously sought, shouldn't have been sought, this is what happened, and the court then immediately rescinded that judgment. So you understand what erroneously sought. Same thing, erroneously granted. The court thought that it was what the parties had wanted, but it wasn't, and it granted erroneous. People make mistakes. So that's what erroneously sought or granted in the absence of the party affected thereby. And then also in respect of interest or costs granted without being argued. So often the court would say, all right, I give judgment in favor of the plaintiff in an amount of 30,000 or 50,000 Namibian dollars, together with interest at the rate of 10% per annum, whereas 20% was sought. No party ever addressed the court on the issue of interest. Same as to costs. I'm going to deprive the plaintiff of costs, but the plaintiff was never asked to make representations, for instance, on this issue. So then the court can, in terms of Rule 103, vary or rescind that order. Any order in which there is an ambiguity or a patent error or omission, but only to the extent of that ambiguity or omission. So the court, for instance, makes an order, but forgets to make a cost order. Or the order says the defendant must pay the plaintiff 100,000 Namibian dollars, whereas actually the plaintiff was the one suing for the 100,000. There's an ambiguity because no one understands why. These things happen, and in that case, the court can revisit the order. Or an order granted as a result of a common mistake of the parties. So the parties may think that they are entitled to a divorce, order for divorce because this, that, or the other, and then something crops up that seems that they're not entitled to that order, then the court can rescind or vary. This is the other basis upon which a party can then seek a rescission of judgment. And then again, in terms of the common law, which is much like Rule 16, which is on good cause shown, but again is an instance where a party needs to show that this was the reason why judgment was granted in default against me, and this is my case on the merits, good cause, and then there's no time limits, reasonable time in terms of the common law. Bearing in mind that in terms of Rule 103, you need not show good cause. If there's an ambiguity or an error of some sort or an omission by the court, then the court must rectify that without you needing to prove that you have a good cause. And please be mindful of the fact that situations may and often do arise where parties seek a combination of this. So they bring an application for rescission, ambiguity or an error had occurred in the judgment, plus coupled with that, there's an explanation for the delay and there's good cause, and then of course the parties brings an application based on Rule 16, 103. You follow, so you can do a combination of the three, and I often do that where grounds exist for you to proceed in all three. Our courts have accepted that the common law right to seek a rescission of judgment is still applicable, and insofar as a party is entitled to proceed to apply for rescission in terms of the common law. As I said, the common law principles are really principles laid down prior to the rules, and in fact what the rules set out is very much in keeping with the common law. So where a party, for instance, has failed to comply with a 20-day rule, and because if you do that, you'll have to seek condonation. But in terms of the common law, you probably won't be bound by the 20-day rule, and you'll still be entitled substantively and procedurally to then apply for rescission of judgment. Although more often than not, judgments are actually given in terms of Rule 16, alternatively Rule 103. But be mindful of the fact that the common law is still very much applicable. It hasn't been altered or done away with by Act of Parliament. The court, these only relate to either matters where it was default judgment, which means that the court didn't hear both parties and make a decision on the merits. So the court cannot be functus officio. And at the same time, where it's an ambiguity or something that wasn't dealt with, it really is something that can be clarified. So it's not changing it, it's clarifying it. So if there's an ambiguity or an error, that must be corrected. But it's an error, remember, in default of a party. So one of the parties were not there and the error existed, or there's a mistake common to the parties. So the parties sought, for instance, interest, whereas the agreement between all of them missed the fact that the agreement between the parties doesn't make, well, it actually excludes interest. Then the court would be able to rectify that insofar as it's a common mistake. Do you follow that? That's basically the situation in respect of functus. So the court isn't functus, but the court will most certainly be functus once it has heard both parties and made a decision on the matter. So Rule 103 sets out specific instances where the court will not be functus in having made a decision or granting an order. The court can say that you don't meet the requirements of the common law rescission of judgment. So they differ slightly from the rules. So what I'll do is, it's for me to explain the substantiveness of each of these is going to take some time, but what I'll do is I'll bring you heads of argument with an extract of the different requirements for each, and that might help you. I won't ask you this question in the exam. It's substantive law. Just know that these are the procedures that can be applied. So I won't ask you that, but if it's of interest to you, then I'm more than happy to share those heads of argument. Good. I'll do that. Okay, I'll do that. It'll just take me some time to go. It'll take me the whole of the afternoon to explain the differences between the requirements. They both relate to good cause, but there are certain nuances that are different.